So now I would like to introduce our presenter, who is Lindy Ann Mitchell, Head Legal of the Office of Public Procurement. Lindy Ann Mitchell is the legal advisor at the Office of Procurement Regulation and is responsible for providing legal services with respect to all aspects of the organization's operations. She is a graduate of the University of the West Indies Hewden Law School and the University of London. She has participated in a myriad of legal courses and professional as well as academic training in areas such as corporate and commercial law, public law, employment law, cooperative studies, public procurement law, and regulatory framework, as well as project management, corporate governance, and mediation studies. So as you can see, she has a wealth of professional experience. This also includes holding positions at T&TEC, the Education Facilities Company Limited, as well as having appeared before the executive teams, along with her executive teams before the Public Accounts Enterprises Committee and Joint Select Committee of Parliament. Her career has also included working for the Trinidad and Tobago Securities and Exchange Commission and the Ministry of Labor and Small Enterprise Development, where she handled a lot of civil litigation cases, appearing as instructing counsel before the court. Now, I'd allow you to read the rest of Lindy's really nice bio in the profile that was sent to you today. But now I would like to ask her to take the floor and address this topic now that the procurement law has been proclaimed. Now what? So Lindy, I invite you to share your presentation and take the virtual podium.
Thank you very much, Ms. De Silva. Good afternoon to everyone, and again, welcome to part 3 of the Caribbean Corporate Governance Institute Procurement Series. With me this afternoon is Mrs. Delorine Liverpool-Young, our Corporate Secretary, and Natifa Lohman, the Senior Legal Officer. So again, I am Lindy Ann Mitchell, Head Legal at the OPR, and I will be taking you through the OPR's presentation today. Before I begin, I would like to take this opportunity to say thank you on behalf of the OPR to the Caribbean Corporate Governance Institute for inviting us to shed some light on the Public Procurement and Disposal of Public Property Act 2015 as amended, and the impact that its recent proclamation will have on all public bodies and their procurement activities. It is my hope that you will find the knowledge shared today useful in assisting your respective organizations with understanding their obligations under the Act and the regulations and the necessary steps involved in ensuring compliance. So let's start. Now let's take a look at the agenda for our presentation today. Firstly, I will give an overview of the Act. I will introduce the OPR, and then I will go on to explore what is a public body and what is public money under the Act. Secondly, I will explore the obligations that the Act imposes on public bodies and the measures that such public bodies can take to ensure compliance with such requirements. Finally, I will then highlight some of the common challenges that public bodies face as they strive to become compliant with the Act. Now let's take a look at the Act and what it aims to achieve. So the Act was partially proclaimed in July of 2015 via legal notice number 150 of 2015. And the Act aims to provide for public procurement, 1, retention, 2, and disposal of public property in accordance with the principles of good governance, namely accountability, transparency, integrity, and value for money. The Act not only incorporates procurement and disposal of public property, but it also brings the retention aspect and process into focus. Additionally, the Act provides for also the repeal of the Central Tenders Board Act. So after 8 years, and Mrs. De Silva referred to it as a battle, since its date of assent in 2015, the Act finally came into full operation on April 26, 2023, by way of proclamation of the remaining sections via Legal Notice number 106 of 2023. Now you might be wondering who this Act applies to. This is addressed in Section 7, which states that the Act applies to all public bodies and public-private partnership arrangements. For the purposes of this presentation, I will focus on what the Act defines as a public body and the obligations that it imposes on them. This will be explored a few slides later into the presentation. So it is important to note that since its initial partial proclamation in 2015, the Act was subsequently amended on 3 occasions, namely by Act number 5 of 2016, Act number 3 of 2017, and more recently, the Act number 27 of 2020. The Act should therefore be read in tandem with each of these amendments. Apart from the Act and its related amendments, Section 63 of the Act provides for the Minister of Finance to make regulations on the advice of the OPR. And these regulations are important for the operationalization of the provisions of the Act. So the Act is currently supported by 10 individual regulations, which were debated and approved in Senate on February 8th, 2022, and are thus deemed subsidiary legislation. These regulations cover following areas: its challenge proceedings, evaluation, ineligibility proceedings, participation in procurement, pre-qualification and pre-selection, procurement methods and procedures, procurement of consultants, record of proceedings, retention and disposal, and the miscellaneous. These regulations can also be found on the OPR's website at www.opr.org.tt in the Resources tab under Legislative Framework. Now let's take a look at who is the OPR. The Office of Procurement Regulation, or the OPR for short, is established as a body corporate pursuant to Section 9 of the Act. It is a regulatory body governed by an independent board appointed by the President of Trinidad and Tobago after consultation with the Prime Minister and the Leader of the Opposition. The OPR's board was appointed on January 12th, 2018, and currently comprises 9 members in accordance with Section 10 of the Act. It is important to note that the independence of the OPR, which is made clear in Section 13(2)(b) of the Act, which states that the OPR shall not be subject to the direction or control of any other person or authority in the performance of its functions, but shall be accountable to Parliament. The OPR vision is to be a catalyst for transformation through best practices in procurement, retention, and disposal of public property. Now, the OPR is empowered by the Act to perform certain functions under Section 13 and is entrusted with specific powers under Section 14. For the purposes of today's presentation, I will only highlight a few of the OPR's functions under Section 13, but I would encourage you to familiarize yourselves with the relevant sections in order to gain a better understanding of what falls within the OPR's remit and how public bodies may be impacted. So Section 13(1) outlines the functions of the OPR, which includes audit and review the systems of procurement and disposal of public property, review procurement practices and delivery systems on an annual basis to identify best practices, prepare and maintain a database of pre-qualified contractors and suppliers, issue and review handbooks and guidelines in relation to public procurement and retention and disposal of public property. At Section 2A of the Act further provides that in the exercise of its function, the office shall act expeditiously and take such other steps as it thinks fit in order to minimize any negative economic impact arising out of the performance of its functions. We will now treat with the powers of the office, that is Section 14(1) of the Act, which provides that the OPR may, in the performance of its functions, monitor procurement activities and disposal of public property, conduct audits and periodic inspections of public bodies to ensure compliance with the Act, and also issue directives to public bodies to ensure compliance with the Act. So as I mentioned earlier, the Act applies to all public bodies. So now let's examine what is considered a public body under the Act. According to Section 4 of the Act, a public body means the Office of the President, the Parliament, the Judiciary, a ministry or a department or division of a ministry, the THA, a municipal corporation, RHA, a statutory body, responsibility of which is assigned to a minister or of government, a state-controlled enterprise, a service commission, a body corporate or unincorporated entity using public money. As we can see, this is a broad definition of a public body and brings all entities spending public money under this single regulatory framework. Now let's look at what is considered public money under the Act. As I would have mentioned previously, the Act aims to capture all entities spending public money with respect to public procurement and disposal of public property. So what is public money? And Section 4 of the Act defines public money as, that is A, received or receivable by a public body, B, raised by an instrument from which it can be reasonably inferred that the state accepts ultimate liability in the case of default, C, spent or committed for future expenditure by a public body, D, distributed by a public body to a person, E, raised in accordance with a written law for a public purpose, or F, appropriated by Parliament. So now that we have a basic understanding of the Act as well as who and what is expected to govern, let us explore some of the key rules and areas of importance for compliance under the Act. So the Act and the regulation highlights that there's a significant role with respect to the accounting officer and the role the accounting officer plays in retention in relation to public procurement and disposal of public property within public bodies. So an accounting officer is defined under Regulation 2 of the Public Procurement and Disposal of Public Property Procurement Methods and Procedures Regulations. A person appointed by the Treasury and charged with the duty of accounting for any service in respect of which monies have been appropriated by the Constitution or by Parliament, or any person to whom issues are made from the Exchequer account in accordance with the Exchequer and Audit Act, or the CEO or any other person holding the equivalent position in a procuring entity. Now, an accounting officer is responsible and accountable for the procurement performance of their respective procuring entities, and some of their functions include approving the annual procurement plan, including associated resource allocation, reporting to the OPR, and 3, approving or withholding approval of recommended disposals and contract awards in the case of significant, meaning high risk, high value procurement actions upon the advice of the Procurement and Disposal Advisory Committee. So apart from the Act and its supporting regulations, it is also important to note the Exchequer and Audit Act and its regulations, which govern the use of public funds entrusted to the care of the accounting officer by Parliament to procure goods, works, and services. So the financial regulations of the Exchequer and Audit Act set out the accountabilities of the accounting officer as follows. Regulation 4 is responsible for ensuring that the financial business of the state for which he is responsible is properly conducted, and B, that public funds entrusted to his care are properly safeguarded and are applied only to the purposes intended by Parliament. Further, Regulation 5 provides that personally and pecuniarily responsible for the due performance of the financial duties of their departments, and B, proper collection and custody of all public monies receivable by them, and C, for any accounts rendered by them or under their authority. So more information in terms of the accounting officer, the role of the accounting officer, could be gleaned from the general guidelines, framework of internal controls for procurement, which can be accessed on the OPR's website in the resources tab under handbooks and guidelines. Now let's move on to examine who is the named procurement officer for the purposes of this act, as well as the respective roles and functions as outlined within the act and regulations. So it is worth noting that while the accounting officer retains the fiduciary responsibilities for the public body, the act places the responsibility for procurement and disposal of public property of each public body firmly under the purview of the named procurement officer. So as you can see from section 61(2) of the act, for the purposes of this act, a public body shall have a procurement officer who shall be responsible for public procurement and disposal of public property for that body, and shall notify the office in writing of the name and designation of its procurement officer. And if you read on, section 61(3) further provides that a reference to this act to the commission of an offense by a public body shall be construed as a reference to the commission of the offense by the procurement officer referred to in subsection 2, or an officer who purports to act in such capacity. If it is proved that the offense was committed with direct consent or connivance, or B, he with the knowledge did not exercise reasonable diligence to prevent the commission of the offense. Regulation 3 further states that under procurement methods and procedures, the NPO shall be suitably qualified, experienced, and competent to prepare the APP for the approval of the accounting officer or equivalent in public body. So note that a named procurement officer is therefore responsible and liable, but in instances where any other officer assumes this responsibility and acts in the capacity of the named procurement officer, then the officer would be culpable. As we can see, the named procurement officer plays a very important role, and it is therefore crucial to ensure that this individual possesses the requisite skills and competence to manage the complexity of procurement being executed by the respective public bodies. So we're looking at the Procurement and Disposal Advisory Committee. What is this committee? So the procurement process was further revolutionized by the Act and the regulations made thereunder, with the requirement to establish what we call a PDAC. In accordance with Regulation 21 of the Procurement Methods and Procedures Regulations. It should be noted that the PDAC is a creation of the regulations and not the Act. Its effect is to remove and replace the previous tenders committee that existed, some of which would have included members from outside of the public service, from having any direct input in the contract award process, and placing this important function under the control of the most senior officers within the public body. Regulation 21.2 sets out the composition of the PDAC and states that it shall comprise of the corporate secretary, head finance, subject matter expert, and such other members as may be necessary. Regulation 21.3 also provides a member of the PDAC may be sourced from another public body. And Regulation 21.4 further provides that a senior officer shall be appointed as secretary to attend all meetings, but shall not be a member of the PDAC. Often public bodies may not have sometimes the requisite personnel to constitute the PDAC. However, with Regulation 21.3 offers a solution to this problem, as it provides that a member of the PDAC may be sourced from another public body. Now let's move to consider the role of the PDAC and how it plays such an important role in the procurement and disposal process. And the PDAC assumes basically responsibility for the verification of procurement and disposal activities performed by a public body and provides a level of reassurance to the accounting officer that such activities are in adherence with approved policies and procedures, handbooks and guidelines issued by the OPR or otherwise approved by the OPR in accordance with Section 13 and 30 of the Act and supporting regulations. So the PDAC therefore acts as a filter and compliance mechanism in relation to all recommendations prior to same receiving the attention of the accounting officer. And the role of the PDAC is expounded in Regulation 21.5, which provides that the committee shall review reports, recommendations for the contract award, and procurement proceedings and property disposal files to determine A, adherence to the Act and the regulations, B, adherence to the handbooks and guidelines, C, adherence to the approved procurement disposal strategy, and achievement of the objects of the Act. Now, the PDAC therefore affords a level of protection to the accounting officer as it ensures that recommendations are not being approved blindly, and it also serves to further the objects of the Act. So as I would have mentioned earlier, one of the functions of the OPR is to also prepare and maintain a database of pre-qualified contractors and suppliers. And this database, as some of you all may be aware, is known as the Procurement Depository. So under Section 26.1, the office shall establish a database to be known as the Procurement Depository, to which suppliers or contractors can submit information with respect to, among other things, their qualification and experience. Section 26.2 further states that the procurement depository shall be accessible by the public for viewing, and 26.3, a supplier or contractor who submits information to the depository shall be responsible for ensuring its accuracy. We should also further note Section 26.4, which states in conducting its due diligence pursuant to Section 29.1e, a procuring entity may require a supplier contractor who has submitted information to the procurement depository to confirm the accuracy of the information submitted. After suppliers and contractors have registered on the depository, the burden then shifts to the public body or the procuring entity to ensure that all due diligence requirements as mandated by the Act are met. So the due diligence requirements outlined under Section 29 of the Act. According to Section 29.1, A, have the legal capacity to enter into the procurement contract. B, treats with are not insolvent in receivership or bankrupt or being wound up. C, have not been convicted within the past 10 years of corruption or fraud related offenses locally or internationally. D, have fulfilled their obligations to pay all required taxes and contributions. E, have the necessary professional and technical qualification, competence, financial resources, and F, meet relevant industry standard. Section 29(3) further states any requirement established pursuant to this section shall be set out in the pre-qualification or pre-selection documents, if any, and in the solicitation documents, and shall apply equally to all suppliers and contractors. So it is important to note that Section 29(1)(c) was also amended by Act number 27 of 2020. And prior to the amendment, the subsection related to the conviction of any criminal offense, which was deemed to be too wide, since it meant that the conviction for small offenses, such as traffic offenses, will be captured under the subsection. That is C, which is highlighted in red. So now let's examine what the Act defines as pre-qualification and pre-selection. So Section 4 of the Act defines pre-qualification as the procedure to identify, prior to solicitation, suppliers or contractors who are qualified, and pre-selection as the procedure to identify, prior to solicitation, just a limited number of suppliers or contractors who best meet the qualification and criteria for the procurement concerned. Now, the Public Procurement and Disposal of Public Property Pre-Qualification and Pre-Selection Regulations 2021, however, outlines the procedures to be followed by both the supplier and the contractor and the procuring entity with respect to pre-qualification and pre-selection. So Regulation 3 states a supplier or contractor, 3.1, a supplier or contractor shall register in the depository and upload all the required information and supporting documents to enable a procuring entity to determine whether or not it meets the criteria for pre-qualification. And you will also want to note Regulation 8, where procuring entity shall only invite suppliers and contractors who are pre-qualified in the procurement depository to participate in procurement proceedings. For more information on the pre-qualification and pre-selection aspect, it is advised that the public bodies also consult with the OPR's handbook and guidelines on pre-qualification and pre-selection, which can be accessed on the OPR's website. So basically, the requirement for public bodies to comply with the requirements of the Act in relation to their procurement and disposal activities is emphasized by Section 6.1 of the Act, which provides that any procurement of goods, works, or services, or retention or disposal of public property that is not done in accordance with this Act, and any procurement contract or agreement that is not entered into in accordance with this Act shall be void and illegal. So now let's explore what is meant by a standstill period for the purposes of this Act. Now, Section 35(2) to 6 of the Act provides for the introduction of this standstill period into the procurement proceedings. And Section 4 of the Act defines what is this standstill period as the period from the dispatch of the notice of decision to award a contract as required by Section 35(2) of the Act, during which time a procuring entity cannot accept the successful submission, and suppliers or contractors can challenge the decision. So the purpose of the standstill period is to just allow a short delay between the identification of the successful submission and the award of the procurement contract or framework agreement, so that any challenges to the proposed award can be dealt with. A request for review by the OPR of a procuring entity's procurement decision is to be made in accordance with the rules governing challenge proceedings under Part 5 of the Act and the challenge proceedings regulations. So subsection 2, you will also want to note that subsection 2 provides that a standstill period shall not apply to awards of procurement contracts where a procuring entity determines that urgent public interest considerations require the procurement to proceed without a standstill period. And further, a procuring entity shall set a standstill period which is not fewer than 10 working days and not more than 15 working days in the first instance, in accordance with the guidelines issued by the office. This is Regulation 7 of the Evaluation Regulations. It should be noted that the general guidelines also on standstill period would have been issued by the OPR and is available on the website. And same should be read in accordance with the Act, the regulations, and the handbooks and guidelines issued by the OPR. So now we will move and cover some of the compliance requirements under the Act. Let us now explore the approach that public bodies can take to ensure compliance with the Act. So the OPR has developed and issued a readiness assessment checklist, or we refer to it as a RAC, a roadmap for compliance, as well as a pictorial roadmap for compliance with the Act. And this is basically to assist public bodies in becoming compliant with the Act by providing an understanding of the steps to be taken for compliance. And it should be noted that the purpose of the RAC is to assess the progress made by public bodies in complying with the Act. The RAC is to be used in conjunction with the roadmap for compliance, which outlines a series of comprehensive steps to be undertaken by public bodies in their transition towards compliance with the Act. And it highlights the necessary support systems required to enable efficient monitoring and the reporting by public bodies. So before I proceed, I would like to emphasize, though, that the RAC and the roadmap are not intended to be an exhaustive list of requirements for full compliance with the Act, regulations, and the handbook and guidelines, but outline the fundamental elements in the thrust towards this move of full compliance. So now let's take a closer look at some of the steps that public bodies can take to ensure compliance with the Act. So we have one, which is to establish a code of conduct for public procurement and retention and disposal of public property in keeping with Section 31 of the Act. And this code of conduct for public officers and suppliers and contractors involved in public procurement and disposal of public property will establish standards of conduct for key stakeholders involved in the process. And it's to ensure adherence to the overarching values enshrined in Section 5 of the Act. Number 2 on this compliance roadmap is to establish an internal control framework for procurement. An internal control framework is the mechanism which will provide public bodies with reasonable assurance that the objectives will be achieved and to ensure effectiveness and efficiency of operations. It is a key tool in strengthening accountability and ensuring clarity in responsibilities. It is also will allow public bodies to have a system in place to mitigate any risk to the achievement of the procurement and disposal objectives, such as ensuring adequate segregation of responsibilities in the procurement and disposal function. Now, the third compliance requirement we have on this roadmap is to undertake a needs assessment and determine procurement capacity needs. All public bodies utilizing public money must ensure that it is appropriately resourced to execute procurement, retention, and disposal activities in a manner designed to achieve the objects of the Act. Public body must therefore undertake an assessment to determine the capacity needs for the establishment of a procurement and disposal function or to enhance the existing capacity based on size, mandate, and level of expenditure. The fourth item looks at the establishment of the procurement and disposal function and inform the office of the named procurement officer. So having identified your human resource requirements in the capacity assessment undertaken, public bodies must establish a procurement and retention disposal function based on the approved structure and budget. This involves appointing an NPO with the appropriate level of competence to manage the procurement and disposal portfolio of the public body and notifying the OPR of same. The fifth item looks at developing the handbooks and guidelines to establish support systems for procurement and disposal. And in accordance with Section 30 and 54 of the Act, public bodies are required to adopt and comply with the handbooks and guidelines issued by the office, or they may choose to amend same or develop special guidelines to suit their specific operations, which are submitted to the OPR for approval. Public bodies must ensure that the appropriate systems are also implemented to support the efficient management and execution of procurement, retention, and disposal activities. This includes establishing a reliable, efficient management system related to risk, records, as well as stores and inventory within each public body. The sixth item touches on appointment of the PDAC and Disposal Committee. As discussed earlier, all public bodies are required to establish a PDAC in accordance with Regulation 21 of the Procurement Methods and Procedures Regulations. Additionally, in accordance with Section 55 of the Act, all public bodies must also establish a disposal committee, not comprising less than 3 officers, for the purpose of recommending the best method of disposing of unserviceable, obsolete, or surplus stores or equipment. 7 touches on the conduct, training, and capacity building aspect, and the system of public procurement, retention, and disposal of public property, as proposed by the Act, requires that individuals and institutions involved in executing the procurement function are highly skilled, capable for the benefits to be derived in full. Public bodies are therefore required to provide internal training for staff. They must also sensitize them on the requirements of the Act's regulations, handbooks, and guidelines, and special guidelines, if any, that are approved by the OPR. It is advised that public bodies assess the capacity of the staff of the procurement and disposal unit against the standards developed by the OPR, that is the training standards, competence level, and certification requirements for procurement and retention and disposal of public property. These training standards can be found on the OPR's website in the Resources tab under Handbooks and Guidelines. The 8th item treats with the annual procurement plan and the annual schedule of planned procurement activities. And the APP, as we refer to it, is a key instrument for successful procurement implementation. And it facilitates a sound judgment and the selection of the most suitable procurement approach, while also identifying aspects of procurement to be targeted to performance management. So in accordance with Section 27 of the Act, you will know that all public bodies are required to 1, prepare their annual procurement plan and annual schedule of planned procurement activities, submit the annual procurement plan to the OPR within 6 weeks of the approval of the national budget, and then thereafter publish on its website or any other electronic format the annual schedule of planned procurement activities for the 12-month period post the national budget. Now, with respect to the item number 9, establish a mechanism for compliance with the reporting requirements in the Act and fulfill obligations. Now, the Act outlines several reporting requirements that you will wish to note that all public bodies must comply with as part of the thrust to promote transparency, as well as to ensure that the procurement system is functioning as required. So some of the reporting requirements you would wish to note is the publishing notices of award of procurement contracts or framework agreements on its website or any other electronic format in compliance with Section 36(1) of the Act. Also preparing and submitting quarterly reports to the OPR 3 weeks after the end of each quarter, that is in compliance with Section 37 of the Act. And the third item, preparing and submitting the annual procurement performance report to the OPR within 6 weeks of the end of the fiscal year. The 10th item on this compliance for roadmap, establish an internal system to monitor performance. And what does this mean? Public bodies are required to establish systems to monitor the performance of their procurement and disposal function, and to ensure ongoing compliance with the Act, regulations, and handbooks and guidelines approved for their use as part of their program of continuous improvement. So this process involves continuously monitoring the execution of procurement and disposal against performance plans, and identifying weaknesses or gaps and implementing measures to improve performance and address any weaknesses or gaps identified. So these 2 slides just provide a snapshot of the readiness assessment checklist circulated to public bodies. And again, all public bodies are reminded that all materials in relation to readiness assessment can be found on the OPR's website in the resource tab. Now that we have finished exploring the compliance requirements in relation to public bodies under the Act, let us briefly examine the challenge proceedings as provided for under Part 5 of the Act. Now, the guide to enactment of the ancestral model law on public procurement, against which the Act is modeled, has recognized that a key feature of any effective procurement system is the existence of a mechanism to monitor that system's rules are followed and to enforce them if necessary. One such mechanism is the challenge proceedings, and this is in which the suppliers and contractors are given the right to challenge a decision and actions of the procuring entity that they allege are not in compliance with the rules contained in the Act or regulations. So according to 49(1) of the Act, a supplier or contractor may bring a challenge proceedings where it is alleged that a procuring entity made a decision or took action that is not in compliance with this Act, and the supplier or contractor has suffered or is likely to suffer loss or injury because of the decision or action of the procuring entity. Section 51, a supplier or contractor may apply to the office for a review of a decision or an action taken by a procuring entity in procurement proceedings. So the procedure for challenge proceedings is further outlined in the regulations for challenge proceedings, which should be read in tandem with the provisions under Part 5 of the Act. For more information on challenge proceedings, also participants are advised to consult with the challenge proceedings challenge tab on the OPR's website. So now let's take a look at what is considered the ineligibility list for the purposes of this Act. And Section 58(1), the ineligibility list is a list basically of suppliers and contractors who shall not participate in procurement proceedings. And Section 58(3) sets out where the office may add a supplier contractor to the ineligibility list where the supplier contractor A, consistently fails to provide satisfactory performance, B, is found to be indulging in corrupt or fraudulent practices, or C, is convicted of an offense under this Act. Section 58(6) A and B where a supplier contractor is added to the list, and any information relating to the said supplier contractor that is stored on the depository shall be removed, and the fact of this addition shall be published and communicated to all public bodies. Public bodies should also note section 58.5, where supplier contractors shall be accorded an opportunity to be heard and to make representation before he is added to the ineligibility list pursuant to this section. Now, the procedure for ineligibility proceedings is outlined in the ineligibility regulations. And I would like to also mention that the OPR is currently in the process of rolling out further information with respect to ineligibility on its website. So you do look out for that in the near future. So I would now like to highlight some of the offenses and penalties under the Act. I will not go through all that are listed on the slides, but will make mention of just a selected few. So we have under section 14.2, failure to comply with a direction by the OPR issued under the Act to ensure compliance with the Act, and the specified penalty is $100,000. We also have section 39, failure for procuring entity to comply with the requirements with respect to confidentiality of information, $500,000 and 1 year imprisonment. Section 46, where it covers concealing or destroying information required for an investigation, $5 million and 10 years imprisonment. 59.10, conduct influencing public officer, 1 million and 5 years imprisonment. 61, bid rigging, influencing procurement proceedings, 5 million and 10 years imprisonment. I will now move on to highlight some of the common challenges that are faced by public bodies in their efforts to become compliant with the Act. So some of the common challenges we observed and some of the queries coming into the office. As mentioned earlier, all public bodies, number one, is to treat with the naming and selection of an NPO. And all public bodies are required to appoint an NPO and inform the OPR of such appointment in accordance with section 61.2 of the Act. Public bodies are also advised that in determining who they appoint as their respective NPO, ample consideration should be given to the roles and responsibilities attached to the position, as well as the qualification, skills, and competencies required. So two touches on the status of handbooks and guidelines, what to follow in the absence of an internal process or procedure. So in the absence of internal processes or procedures within public bodies to guide their procurement, retention, and disposal activities, it is advised that such public bodies consult with the Act, regulations, and the handbooks and guidelines issued by the OPR to guide such activities, thus ensuring compliance with the Act. Such public bodies are also advised to consult with the OPR's general guidelines framework of internal control for procurement to aid with their development of the necessary internal procedures and processes. Where the nature of the public body operation is unique, such public bodies are advised to develop their own special guidelines to govern that particular procurement activity and to submit same to the OPR for its review and approval. The third issue I will touch on is conflict of interest, request for advice in relation to the existence of a lack of segregation with respect to duties of key personnel. So public bodies are advised to structure their units, procurement units, in a manner that promotes segregation of duties of key actors in the procurement process. The OPR's general guidelines, which is the framework of internal control for procurement, should be used as a guide in developing the appropriate structures in alignment with the Act and its objectives. So where conflict of interest arises, however, public bodies are to be guided by the OPR's guidelines on ethical code of conduct for public bodies and public officers, which states that public bodies and public officers shall ensure that all persons with direct influence on the recommendations and decisions of a procuring entity shall declare any interest that they may have in the tender and shall, so far as possible, recuse themselves from the proceedings. The other challenge that we saw is identified under number 4, the depository. That is the selection of lines of business and the public body credentials. So with respect to accessing the depository, it should be noted that the NPO and AO of all public bodies are granted access to the depository. To access the depository, the AO within each public body would be required to send an official correspondence to the procurement regulator indicating that a named person has been appointed as the procurement officer who shall or who will subsequently be provided with login credentials for the depository. And a template for the request can be found on the OPR's website in the Portals tab under Procurement Depository. Public bodies may also request that additional users be added to the depository. However, any such request must be submitted by completing the public body letter template, additional user found on the OPR's website, and uploading the letter signed by the respective AO to the change request section on the procurement depository. With respect to the lines of business on the depository, it should be noted that a line of business refers to any goods, works, and/or services available to the public body. Lines of business are inputted on the depository using the United Nations Standards Product and Services Code, or UNSPS code as we call it. A public body can create as many lines of business that it requires, as well as view or delete existing lines of business. Additionally, a public body can pre-qualify suppliers and contractors in those said lines of business. Once a public body pre-qualifies a supplier or contractor for a line of business, the supplier or contractor becomes pre-qualified to participate in procurement proceedings in respect of that line of business by and all public bodies. With respect to number 5, determining financial delegation of authority with respect to value thresholds, public bodies are responsible for establishing their own financial delegation of authority with respect to value thresholds. Public bodies should note regulation for 2 of the procurement methods and procedures regulations, which provides that a procuring entity may establish specific threshold values in special guidelines and handbooks. As noted previously, some are to be submitted to the OPR. It is to be submitted to the OPR for its review and approval. With respect to issue 6, lack of personnel to constitute a PDAC as mandated by the regs, as noted previously, where there's a lack of personnel within a public body to constitute a PDAC, the public body may choose to source the respective members from another public body. With respect to the absence of a procurement unit, how are procurement activities to be conducted in the absence? With respect to the absence of the procurement unit, section 61(2), we should note of the Act is reiterated, which provides for the appointment of an NPO within each public body who will be responsible for public procurement and disposal of public property for that body. It should be noted that for a small public body with a relatively small annual budget and a small number of low-risk, low-value purchases, it may be sufficient for that procurement unit, for the procurement unit to be staffed by an individual. In addition, based on the circumstances, it may be more efficient and prudent for the NPO to be a member of staff with other duties to perform. Number 8 treats with the uncertainty as to whether certain organizations are captured under the definition of a public body under the Act, or whether they utilize public money whether there's uncertainty regarding whether a particular organization falls within the definition of a public body under the Act, or whether it utilizes public money as defined by the Act, such public body may seek clarification from us in relation to same. With respect to issue number 9, how to pre-qualify suppliers and contractors on the depository. So with respect to the pre-qualification of suppliers and contractors, it should be noted that public bodies are responsible for this exercise and not the OPR. Public bodies are required to invite suppliers and contractors to register on the depository, after which the public bodies will conduct the necessary due diligence checks in alignment with the Act, and where it is determined that the respective suppliers and contractors have provided the relevant information in compliance with the Act, the public body can proceed to pre-qualify such suppliers and contractors. It is important to remember that a supplier or contractor is not automatically pre-qualified for all goods, works, or services it inputs into the depository. Pre-qualification for each supplier or contractor is limited only to the specific lines of business. That is for those goods, works, or services for which is pre-qualified by the public body. So public bodies are encouraged to consult the pre-qualification and pre-selection regulations, which outlines the procedure for pre-qualification that is to be adopted. So I would have touched on here some of the common challenges the office faced, and just try to provide some responses to same. And this would bring me to an end of my presentation today. I would like to thank all the members for your kind attention, and I hope that the information presented assists in providing some clarity to any of the questions that you may have regarding compliance within this new procurement framework as provided for under the Act and its supporting regulations. So thank you, Mrs. De Silva.
Thank you very much, Lindy Ann. This was such an excellent presentation, and it really did help clear up quite a bit of questions that I myself have had. However, you will see that in the chat there are a number of questions, so there are still some things that persons would like answered and addressed. So the way we would proceed is I'm going to give the OPR some time to look at all of those questions and compile some responses which they would bring to us. However, we do have our panel discussion to follow, and also our panelists may not all be able to stay until the very end, but I'm hopeful that the team from OPR will be. Delreen, so I'm asking for your team to go through the questions that are in the chat, please. And after we've had some discussions from our panelists, would it be okay that we can invite a member of your team?
Sure, Kamala, that's fine.
Okay,
So we
awesome.
compile the questions and give the responses at the end.
Yes, because I think that there are a lot of things that persons do have questions about and will want to get a response. So I'll give your team a little time to be able to go through them. And if there are further questions, persons can continue to place those in the chat. Some of you may know we have been doing this procurement series. This is our 3rd year that we have been looking at the issue of procurement and what is happening here, particularly in Trinidad and Tobago. Now, as the legislation was being proclaimed, we reached out to the OPR, in fact, even before this, to ask for some companies, because there are many organizations which have been trying to ensure that they comply with the regulations and with the Act in anticipation of proclamation. But we knew that there were also a lot of questions from those agencies which had not yet completed compliant or were looking for some further guidance. Therefore, we invited and are very happy that we were able to bring here representatives from National Gas Company and from T&TEC. So I'm going to introduce our panelists, give you just a very brief background, because I know there's so much to discuss and you have been given their profiles in the agenda, which was sent out to you via email this morning. If any of you didn't get it, you could let us know and we'll just put it in the chat for you, okay? We will begin our panel. The way we will go, we'd ask each of them to present for 8 to 10 minutes on some key points in terms of where their organization is at in terms of the adhering to the law, what may be some lessons learned and some key points and guidance they would like to share with the rest of us. So we'll start with Mr. Kurt Scotland, who is the Senior Manager, Supply Chain Management at the National Gas Company of Trinidad and Tobago. So Mr. Scotland has over 18 years of proven experience in accounting, audit, and supply chain management, and a wide-ranging international supply chain experience in both the upstream and downstream sectors. In his current position of senior manager, as part of the leadership team, he oversees the strategic sourcing of high-value, sensitive, complex, high-profile requirements with due regard afforded to cost, quality, health and safety requirements, as well as schedules variables that are consistent with NGC's contracting policies and procedures, as well as ensuring long-term planning for the strategic objectives of the supply chain division, which he heads. So he has an MSc in accounting with distinction from Long Island University, as well as a BSc in administration and accounting and finance with a double major from the Long Island University. We also now have our 2 representatives from T&TEC. We have Mr. Curvis Francois, who is the Chief Operating Officer. He is in fact a power distribution engineer. He graduated from UE with a BSc in electrical and computer engineering in 2006 and earned an MBA degree from the Arthur Lockjack Global School of Business. He has worked with the electricity sector for 33 years, and as a project management professional has pioneered implementation of an enterprise GIS within the commission. And we have Ms. Nasilee Smart, who is the Procurement and Supplies Manager at the Trinidad and Tobago Electricity Commission. She is a supply chain specialist with over 20 years of experience. Prior to joining T&TEC in 2004, she worked at a number of public and private sector companies, including Trackmark Engineering and Whitco. Her experiences have spanned the field of procurement, inventory management, warehousing, and logistics. She holds a BSc in Industrial Management from UE, a diploma in Procurement and Supply, the MSIPS from the Chartered Institute of Procurement and Supply, and she also has an executive MBA from the Arthur Lockjack Global School of Business, where she was awarded the Research Award for Most Innovative Entrepreneurial Project. So as you can see, we have 3 panelists who are extremely distinguished and would be able to provide a lot of value here as we discuss the procurement legislation, and now that it's proclaimed, now what it means. So Mr. Scotland, I go to you first and ask you to share with us your key thoughts.
So good afternoon all. And again, Kamala, thank you for the opportunity and for the invitation to share some of NGC's journey with the members today. And again, you told me I couldn't do a PowerPoint presentation and just probably talk around some key points. So for the NGC, you know, we've been hearing about the proclamation of the Act for quite a number of years, and you know, there were a few dates set and missed, and lo and behold, we had the proclamation in terms of April 26th. So during that time, however, The NGC being in the industry it is in terms of the oil and gas sector, in terms of the energy industry, we have always ascribed, to best practice in terms of procurement, by the nature of our industry, dealing with the Shells and the BPs and those upstream companies. We have always sort of framed our procurement and contracting framework in that best practice. So we, not to boast, but we were already like more compliant with the act, the guidelines and the regulations, because again, that was the nature of how we operated with our day-to-day business. So our challenge now, more or less, or our focus now is more or less alignment, where we can ensure our policies and procedures kind of pick up a lot of the stuff that are in the guidelines. So one thing I am pleased with so far is that the forward thinking, I guess the forward thinking of the OPR in terms of including sustainability into their guidelines. So sustainability and the green agenda is, while it has been in the background, is now at the forefront in all industries. And I think the OPR in developing their guidelines did a very good job in looking at sustainable procurement. So for younger companies coming in, because that has certainly been the thrust now in NGC, where we're looking at sustainability and green agenda. If you guys see that there's currently a sustainability conference going on that has started over the last 3 days at the Hyatt. So now I applaud, I guess, the OPR for that forward-thinking mentality in terms of being on the cusp of what is developing. So for us at NGC, we were able to take a look at those guidelines, coupled to what we have already been doing, and sort of enhanced our policies and procedures to align with what the act or the guidelines have prescribed. So that was really good for us in terms of taking a look at what the OPR has done around sustainability and sustainable procurement, and being able to build some of that into what we currently do. So we've actually started building a lot of the sustainability and green initiative into our processes. So for example, we've built it into our pre-qualification process, we're building it into our tender process, and then contract award and evaluation. So for example, once companies can demonstrate that they have incorporated some sort of green or sustainability initiative into their work practices, that may they may get a 1 or 2 points in terms of their pre-qualification during evaluation, or their or during the tender process in terms of the evaluation. Another positive for me in terms of the proclamation of the act and contained in the guidelines, sorry, I lost my train of thought, was around the contract management framework. A lot of times, a lot of value is lost in the contractor management piece, where based on, I guess, poor contractor management, there's room for a lot of variations to creep in. So I was pleased to look at, again, in terms of the guidelines coming out of the OPR, that they adequately addressed the cycle of contractor management. So that was really good for us in NGC, and it actually supporting us in developing our contractor management framework. So another important thing for us was in terms of the capacity development skills. We've been on a journey in NGC in terms of what we call CKSD, competence, knowledge, skills development, and it was heartening to take a look at the training and capacity guidelines and pull pieces from that, so we could have incorporated into our own CKSD for our procurement professionals to support in their development. So that way, now that we ensure that we aligned across the country as it relates to our procurement professionals, in terms of at least in the public sector. So there was some very good good information that we pulled, at least from the guidelines and from the regulations, in terms of supporting us in the development of our own internal procurement and contracting processes. We do, however, have some challenges. in that while the NGC has been around for the last 45 years and counting, and we have developed our procurement practices and procedures, so we consider ourselves more or less a mature procurement organization. And a lot of the guidelines and so forth, kind of mention a specific format or specific template that must be utilized, when we may not necessarily speak in that language to our leadership team or to our stakeholders. So it forces us now to kind of go back and try to conform to maybe the language spoken by the OPR, so that again they can review our information in a more I guess in a systemic way. So I may have to probably do two sets of, or right now we're struggling administratively in terms of trying to align. So I noticed, Lindy Ann, that when you presented the checklist, the RAC, that you utilized the old one, because the one that you put up on screen has the 33 items. There's actually a new one that you guys have put out recently that has actually 50 items. So the RAC is no longer 33, is actually now 50. So whereas I was thinking that I was compliant maybe 2 weeks ago and I was at 75%, now I have to go back and look at an additional 20 items to determine what additional work I need to do to be compliant. But again, all in all, again, the proclamation of the act has been a good thing. We at NGC, we may be at a different place. We probably maybe in the top 1, maybe the top 3% of where we are in terms of our procurement functions. And we definitely will work closely with the OPR to ensure that we are all aligned as to how we move forward. And again, support the OPR where necessary in terms of being, I guess, mentors for, I guess, other state agencies when it comes to support and developing their functions. I know we have had engagement with NEHURST, we have had engagement with WASA in terms of supporting, in terms of development and, just kind of review of policies and procedures and so forth. So we had down a good path so far. I hope I didn't talk too much. And I'm within my 8 minutes. And I would now, I guess, hand back over to Kamala and the other esteemed panelists.
Thank you very much. And I know you didn't talk too much. You have given us some good food for thought already in terms of what may be some of the things that other organizations would also encounter. And so how do we work that through? So thank you, Kurt. And now we'll ask Mr. Francois. Let's hear from T&TEC points of view in terms of your ability and how well you have done in terms of compliance with the Act. And what were some lessons learned you may wish to share with us?
All right, thank you very much, Ms. Rapasad Silva, and to the Caribbean Corporate Governance Institute for this session here. Pleasant good afternoon to all members, the OPR, fellow panelists, ladies and gentlemen. The Trinidad and Tobago Electricity Commission is the sole electric utility in our nation, and we are mandated via the T&TEC Act, Chapter 5470, to provide a reliable, safe, and adequate supply of electricity to our domestic, commercial, and industrial customers. In the conduct of this responsibility, the Commission purchases power from various independent power producers, call them IPPs, and via its transmission and distribution system, delivers that power to over 516,000 customers. Apart from its purchases related to its electrical generation, the Commission's annual procurement spend exceeds $300 million. The Commission operates a hybrid procurement system in which stock items, which are predominantly utility materials and equipment, are procured by the Procurement and Supplies Department, and our non-stock items, which is other goods, services, and works, are procured by the various departments according to their needs and their budgetary allocations. So that's just a little introduction into T&TEC. The Commission had been diligently working towards its readiness for full compliance to the full proclamation of the procurement legislation for a couple of years now. However, on April 26, 2023, when full proclamation was made, the transition from the old to the new procurement dispensation was far from seamless. We had already checked off most of the items on the OPR's readiness assessment checklist. We had developed codes of conduct for public procurement. We had developed internal control framework, undertook the assessment to determine capacity needs, and adopted an improved organization structure. We established a procurement retention and disposal function. We developed the necessary handbooks and guidelines. We appointed a PDAC committee, and we already had a disposal committee before that. We conducted training and capacity building, and this is ongoing. We prepared the annual procurement plan. So we did almost everything that needed to be done according to the readiness assessment checklist. Yet the transition revealed unforeseen gaps and serious challenges. Chief among them was the pre-qualification process, with the inability, tardiness, and probably unwillingness of various contractors to register and pre-qualify on the OPR depository. With the mandatory engagement of OPR pre-qualified suppliers only, this has posed a significant challenge to us. Then we have the role of the PDAC committee, this is the Procurement and Disposal Advisory Committee, who now has to review and recommend the more than 10,000 individual procurements that the Commission engages on an annual basis. And finally, the smooth continuation of our business processes during this transitionary period has been challenging. As a state agency, as statutory body, the Commission is very mindful of its fiduciary responsibilities to account for its usage of the funds it generates on behalf of the state, and its obligations to ensure that it complies with all the relevant legislation, including this one, the latest procurement legislation. As a result, our procurement activities have slowed somewhat, while we instruct, quote, and beseech our suppliers and contractors to register and pre-qualify on the OPR's online depository. For the various lines of business that the Commission has already registered, we have registered over 1,700 lines of business. However, only 227 of these lines we have had pre-qualification requests for, and only 74 suppliers and contractors have actually been pre-qualified. And this represents a very tiny percentage of the contractors and suppliers that we deal with on a daily basis. So on an ongoing basis, the Commission utilizes a few thousand suppliers and contractors, given the nature and the size of our business. So 74 is really just a drop in the bucket. That being said, though, the Commission supports the need for this procurement legislation. We understand its importance in ensuring integrity, accountability, transparency, and value for money in public procurement. We will therefore do what is necessary to ensure full compliance by the agents of the Commission as we work collectively towards overcoming the teething problems associated with this transition. Right? So that is essentially, in a nutshell, what we are going through. I would pass on, however, to Ms. Smart, Nasilee Smart, who will go into a bit more detail into some of the challenges as well as some of the solutions that we have implemented. Thank you.
Good afternoon again to everyone, and thank you, Ms. Silva and the Caribbean Corporate Governance Institute for having us here this afternoon to share our experience with this new transition. So as Mr. Francois said, he gave some background into some of the challenges we would have had. Just to put some context into it, Trinidad and Tobago Electricity Commission has 6 core operating areas. So we would call them by where they are located: distribution east, distribution south, north, central, and Tobago. We have 6 main administration buildings. This is separate and apart from the areas. And then we have 14 commercial offices. So each of these locations would generate a demand, a need, and hence results in our high volume of procurement. It also results in us needing some amount of flexibility and therefore operating the hybrid model in terms of decentralized along with some centralized elements of procurement. That being said, applying the Act and how the Act is conceptualized to our model would have its challenges. And in today's webinar, we're just basically looking at 3 core challenges that we've been having. One is in terms of the use of the OPR depository. And that is in context again with our volume of transactions. So Mr. Francois would have given some details in terms of the pre-qualification process. We need to attach our lines of business, which goes down to a very granular level in terms of the commodity. Each supplier needs to pre-qualify by their commodity, and with each commodity that they pre-qualify for, you get an email. So one supplier, let's say, of stationery at its simplistic level, would carry a whole inventory of stationery items, pens, pencils, erasers. And you may find that each one of those items, they may have to pre-qualify for. Each one of those items, you may have to say yes for. So hence accounting for the large number of lines of business that you would have to register, set up in the system and therefore pre-qualify suppliers for. So we have engaged the process, and as he has indicated, we have set up lines of business and we are actively proceeding with trying to pre-qualify suppliers, which brings another one of the main challenges we have. A large component of our suppliers are foreign suppliers, and they themselves have had challenges in walking through the system and being able to reach that pre-qualification button. So you would have suppliers calling you and said, well, yes, I went into the system and I registered. And sometimes it's just the basic information they've put in and they have not uploaded, they have not registered for their lines of business and they have not clicked that publish and pre-qualify button, which then allows us to see them and say, yes, we can pre-qualify. So we have had to walk local and the foreign suppliers through the system, right? Yes, we have directed them to the OPR presentations, the OPR guidelines in terms of how to use the system. But even in them, going through those documents, we've still had to do a bit of hand-holding to take them along the way. In terms of going through the pre-qualification exercise as well, suppliers that have gone in and have loaded documents that are not valid, right? Or sometimes not applicable to what they are loading for. So we've had to go back to them and say, well, okay, and the system does allow you to send an email to them. But sometimes it works faster if you call them and explain to them you have not loaded the appropriate document. This is the document that we need to see in order to have them pre-qualified in the system. We've had some challenges with some of the international suppliers, indicating that they're simply not interested in and assessing whether or not they are going to go through the process of pre-qualification. So that we're still navigating around, because in some instances, these suppliers provide key services to our organization. And in some cases, they are sole suppliers. So we have to navigate around that hurdle as well. All right, so having dealt with on the pre-qualification side, we've also interacted with some of the reports required by the database. So in the regulations and in the legislations, it would have been indicated that we are required to provide some quarterly reports on procurement and so forth. But how the database is also set up, it requires us to enter each procurement into the system. So there's a bit of a question mark as to, okay, would the reports now come from the system, or are we still going to be required to submit these reports? And then considering our volume once again, in terms of the number of transactions that we do, to what extent is the system expected to take these transactions? Because the Act does talk about thresholds in context of which procurement method you use, but it does not really speak to thresholds in terms of what are you reporting on. And even to go to the other challenge we have is the role of PDAC. The Act specifically says that, PDAC is responsible, and as Lindy Ann would have shown in the slides, for review of procurement awards and contracts. Again, it does not say a value. So it seems to imply that every procurement transaction, be it at, let's say, $1 to infinity, is required to be reviewed by the PDAC committee. And again, in context, the high volume of transaction that the commission does. And this high volume considers as well if we are to amalgamate some procurement. So we do understand that we operate some amount of decentralized activities for flexibility, and we may have to look at that and say, well, okay, we would have to amalgamate it, properly plan it so that our areas are able to operate without compromise, but at the same time meet the requirements of the legislation. So it's a balancing act, and it's quite early in the game to say how exactly we are going to address each one of these factors. So the other third, so we just talked about three main challenges that we have seen on the horizon, right, is addressing the annual procurement plan. So as Mr. Francois said, we did about 2 or 3 years ago initiate the annual procurement plan. So we did amalgamate all procurement, we did produce the list of procurement activities, and we did do the plan itself. And that was one of the learning groups. We realized that this is not an activity that you can do via Excel spreadsheet system. So we set about developing our own internal software per se to amalgamate that information for us systematically, so that we don't have to do a lot of copy and paste and analysis of the data, right? And it was built in accordance with the annual procurement plan guide as rolled out by the OPR. So the items were identified at the commodity level at that time and amalgamated across all departments within the commission. But still, we had quite a few hundred lines of items to consider. And with these lines now, we now have to put it into the project and develop the necessary procurement portfolio analysis and strategy to deal with each type of procurement. So as I said, it's quite early in the game. We are seeing all these things that we have to do. And therefore we are saying, well, okay, we know it's going to be a challenge, especially in the case of the annual procurement plan. Even as Mr. Francois and Mr. Kurt Scotland said, the Act is law, and we are doing all that we need to do in terms of ensuring compliance. Because at the end of the day, at least the three of us sitting in the room would be accountable, right, for any breaches, or at least to answer if any one of our colleagues find themselves in a breach. So the faith of the organization with regards to this law is really in our hands. But as we work through it, we do interact with the OPR to kind of get guidance. There's a lot more guidance needed in some of the areas that we would have kind of pinpointed to. How do we really approach PDAC, especially since it requires the head of certain functions, the head of legal, the head of finance, and a technical expert, right, who are persons or portfolios that already have a full day job per se, right? And this activity, so they have been duly constituted and they're looking at the mountain. We have put systems in place, so it's really to begin climbing the mountain. Right. So with that, I'll close in terms of our challenges.
Thank you so very much. And I really appreciate the candidness with which our panelists have shared here today, because these are the issues which we would need to address if it is we want to ensure that the law is effective to get the outcomes that we want. So I really appreciate the fact that as each of you have shared, it is important that the law is proclaimed. We are happy that it is. So now there's an absolute need for us to work through what are the challenges that organizations are facing. And I know for a fact that the OPR has been very open to requests from persons, whether it is to have a presentation made to their organization or answering specific questions, given guidelines. They have been doing that for a while. But we do know that a number of persons would have waited until the proclamation before beginning to put things in place, and therefore will now need a little bit more of holding hands. So there were so many questions that is addressed to the OPR, and I'm looking at the time and realizing that we are going to possibly run out of time, although I want to tell you, I have some questions for you guys. So maybe we would be inviting you again, because we have to continue this conversation as we try to work through how do we ensure there is a successful execution of this law now. Delrin, may I ask if it is that one of you would be ready to address some of the questions for us? Would it be you?
Between Lindy Ann and myself, we could address some of the questions raised. I know because you said our time is limited and you have questions to pose to the panel members, what we could do is we could compile some of those questions and document it and then share it with you, and you could share it wider.
I actually quite like that suggestion you have made, which is to compile the questions and provide answers to it, which we could then share with all the participants afterwards. So because we may not be able to address all of them. However, there were a few questions which kept repeating in the chat where persons had some concerns with. So let's see if some of these we may be able to address. Some included the fact that what was raised by the panelists too, in terms of when the qualification process itself is presenting a challenge in order to continue operations for organizations.
Right. So if I'm to start with the pre-qualification process, right? So what the OPR, so under the legislation, the OPR has, we had to develop a procurement depository database, which suppliers and contractors could, we looked at that as a data dump. They could give us information as it pertains to, the nature and the qualifications of their business. And then we had to marry that with the section 13 responsibility of the OPR to have a database, to prepare and maintain a database of pre-qualified suppliers and contractors. So when the OPR was developing this depository, we had to pay special attention to the definition of pre-qualification given in the Act. And the definition of pre-qualification is not typically the standard definition. So it actually refers to the procedure to identify, prior to solicitation, suppliers or contractors who are qualified. So how we design the database is very much so like a registry, yes, but because we are the regulators, we had to effectively identify what are the basic or the basic documents that suppliers and contractors would need to have. How the depository is set up is some of those requirements, and we haven't mandated some of those requirements. Right? So when suppliers and contractors go on, they've been asking for basic registration information. And once you publish that, you're then able to click register, and the information is published, and it is the procuring entity now has sight of you being registered on the depository. Mindful of section 29, which is the due diligence section. That section puts the responsibility for pre-qualification of a supplier and contractor on a particular procuring entity. And section 29(1)(e) specifically says a procuring entity shall ensure that suppliers and contractors have the necessary professional technical and competent financial resources, equipment, etc. So I think as it pertains to pre-qualification, the obligation really is on the procuring entity to ensure that their suppliers and contractors are pre-qualified. Now, I understand that because we're in a transition stage, procuring entities are now rushing to identify their lines of business, and that is taking some time. The thing about it is there are lots of suppliers and contractors. My last check was over 4,000, at least over 4,000 suppliers and contractors there. So what you find is suppliers and contractors have gone on, suppliers and contractors have registered their specific line of business, but because procuring entities haven't yet registered their line of business, procuring entities aren't seeing some of the suppliers and contractors. So it's really incumbent on some of the procuring entities to include their line of business. I could say though that we will be doing a campaign later, very soon, a public campaign to treat with some of the issues for suppliers and contractors and procuring entities in terms of easing the process for them to come onto the procurement depository.
And we also noted, Ms. Smart.
Hold on, Miss.
No,
Yeah,
yes,
go ahead.
I was just saying to Ms. Smart that we also noted the granular nature of some of the lines of business, and he commented that that in itself, you know, it being so granular could pose certain challenges also. So that is an item that we are also looking at, and we would try and address that particular issue based on the specific line of business accordingly with our IT people.
So what we suggested as it pertains to that in particular, the line of business, is you know that there's a parent line and then you have children line. So we are looking to have suppliers and contractors register on the parent code. The problem with that, however, is, so that's our interim solution. The problem with that, however, is it would be where a supplier or where a procuring entity is to issue a tender and you put the mother code, it would be incumbent on you as the procuring entity to ensure that you don't exclude suppliers and contractors who fall as the children code, right? So that's one way we propose to deal with that in the interim.
So what I was saying, maybe the system could be set to be optional rather than fixed, so that you have the choice of whether or not you pre-qualify at the parent level. So let's say it's a low-hanging fruit. Using the same stationery, you could pre-qualify for stationery items as opposed to a more technical item where you need the segregation of the different types.
You could possibly put in your line of business as a procuring entity as stationery, but you also would have the responsibility to inform your suppliers and contractors that this is what you're doing. And of course, let's say a supplier and contractor who provides paper versus pens comes to you, it will be your responsibility to, you know, again, be in alignment with the section 29 as it pertains to the due diligence section. The other thing I would say about the lines of business is we would have gotten some concerns or some queries wherein persons would have said, well, oh, I went on and I'm not seeing my line of business. My line of business is so peculiar, I'm not seeing it. So for example, one example would have been preservation services or hangman services, right? Where you have very peculiar lines of business, there's the option to write to the OPR and we create a specialist line of business for you. But we will only create that specialist line of business if your particular line of business is not found on that international code. Yeah.
Okay,
So that
do you mind at the same time dealing with the issue of the foreign suppliers?
So right, sure, no problem. So foreign suppliers. So there are many issues as it pertains to foreign suppliers. The one that I get most often is how do we, as foreign suppliers, mandated to register on the procurement depository? And the answer, unfortunately, based on the regulations is yes. Right? So the regulations actually outline and specify, I'm just flipping to the regulations, that, regulation 8, that you are to, where you aren't able, just now, where you aren't able, then you could pull it for me. Pre-qual and pre-sec. Okay, so that is it. Okay, so you can find it in the pre-qualification and pre-selection regulations. right? And it would be around regulation 8 of that document. It says a procuring entity shall only invite suppliers or contractors who are pre-qualified in the procurement depository to participate in procurement proceedings. Specifically, as it pertains to international, it says that a procuring entity, there's a section. Right, sorry. It says that a procuring entity. So if you don't have a local supplier and contractor and you want to go internationally, you are to place an ad and encourage your international suppliers to come on board the procurement depository. And you are to pre-qualify them on the procurement depository before you engage them. I don't know if that answers the question.
But nothing inhibits the foreign supplier from complying with section 29 also, because with the exception of the taxes, but as it stands in terms of the 29(1)(a) to F, they could fulfill all those other requirements.
Mhm. Now, there is a question that, so just to see if we could get some clarity on this. It's just written again by Heather Joseph in the chat as well, right? So when you're dealing with an urgent request for a particular line of business, now, the fact is the legislation is proclaimed, this is now law. But there's also the responsibility for continuity of businesses. And so where organizations may not have reached at that level, where everything is in place to ensure that they fulfill and comply with the requirements. How can you help?
So that is our section 64 and section 65 of the legislation. So section 65 of the legislation says where there are any procurement proceedings in force upon the commencement of the act. So once you would have commenced your procurement proceedings prior to April 26, it shall be deemed to be in conformity in the act. It's a savings law clause, and those transactions would be saved up to that point. To continue the process, what we've been advising public bodies is that to continue, you now have to be in alignment with the act. And of course, it will go on a case-by-case basis, depending on the stage you are at your procurement. So for example, if you are the Ministry of National Security, you are procuring, you're procuring port scanners, you would have reached the stage of, your evaluation for port scanners have been completed, right? So all your proceedings up to that point would be saved. Your next step would be, let's say, to award the contracts. Well, then you award the contracts in alignment with the act. And what does that mean? You go to, in terms of publishing your notice of award, the legislation speaks to what you put in your notice. It speaks to how you identify suppliers and contractors. So for example, you'll have to put the name of the supplier that was awarded, the amount of the value of the contract, etc. So it depends on the stage that you're at, but your proceedings would have been saved up to that transaction.
Mhm. Okay. Now,
Does that help?
well, I guess everyone has to take some time to process some of these as
Okay.
well. But there's an issue here which I want to ask Kurt Scotland to address. And this came from Kathy and Joseph. I wondered if you might be able to help her, because she said, with respect to the foreign suppliers, some of our institutions need them more than they need us, and therefore it can be difficult to get them interested enough to register. And I
have the
know
same
that
problem.
Yeah.
I have the same problem at NGC in terms of some of the critical components that we use may be specialized in terms of OEMs, original equipment manufacturers, and they onto it because again I guess the quantum of the business that comes from us in terms of this region is not sufficient for them to have us as a tier one vendor or buyer. So yeah, we're looking for a critical valve, or we're looking for a critical piece of equipment, and they don't want to register. I can't stop my business or endanger, I guess, my facility because they're not registered on the OPR. So we need to address that at some point. So yes, with all my encouragement, yes, and where I may spend $2 million with them, where their spend for the year, or they're maybe 2 billion, and I have a $2 million valve that I want to order, and they're not interested in jumping through those hoops in the OPR.
Mhm.
So we need to find, and again, it's not just me, it's not just NGC. We may have other institutions with similar issues.
We do have
So we
other
need-
institutions with similar issues. So what I'll say on that is if you could get them to just register, because all over the world, there are procurement, they are registration database. So CARICOM has a general database where all suppliers and contractors have to be registered. If you're doing business with America, if you're doing business with Australia, you at least have to be registered as a supplier and contractor. So we are not telling you to stop your business, but we're telling you what the legislation says. So at this point in time, for your business continuity, what you may want to do is, if you're proceeding in that regard, if you cannot find an exemption or a manner to proceed with in compliance with the Act, let's say your section 64 or your 65 to justify it, you will have to put that in your internal justification and let it clear through your Procurement and Disposal Advisory Committee as a matter of urgency, etc. Because when we come to audit and investigate, right, we will have some of these things in mind. Of course, we will understand it is transition. However, we cannot give a blanket statement that all you could just freely engage international suppliers and contractors, right? And we also have to be mindful of the, not only the letter of the law, but the spirit of the law, which really is to increase, competition. We have to look at all those things. And while I understand, the for international suppliers, we might just be, a speck in their bucket or a drop in their bucket in terms of it's still, legislation requirements. And even our local suppliers who have to trade internationally, they still have to comply with the international standards. So if we want to progress as a nation, we have to find some way to encourage the suppliers and contractors that we use to come on. So for now, I would tell you to, justify in your procurement documents, and because the regulations also speak to records keeping and justification as to why you're doing what you're doing at this point in time. Of course, the OPR would engage the Ministry of Finance and the other key stakeholders to see what exemptions or what we could do to assist going forward. But of course, that is a legislative amendment. Right. And right now we're not at the stage where we could propose this legislative amendment because we're still in transition and teething phase.
Sorry, I was frozen there for a while. I fell off. My apologies.
Okay, so let's add you back to the panel. But I wanted to say as well, Kurt, I'd let you come back in. But Delrin, I really appreciated your reference to what was the purpose of all this, right? The spirit of the law as well. And I just wanted to bring back to people's minds, the forefront of their minds, the fact that as much as there are a lot of challenges with ensuring that we get the compliance part right, the purpose of all this is because we want to ensure there's a greater level of transparency and accountability. And why? Now, I'm saying this following from a session we had just last week. When you look at some of the cases that has come before our courts, and if we look specifically at the Privy Council decision in the T&TEC case, what was the issue in the T&TEC case? It was procurement. It was the procurement of technology software that cost the country $5 million, which just disappeared. So this is to prevent those kinds of things from happening. So it's not to say that everyone is going to be suspect, but rather if you are ensuring there's proper documentation, there's proper disclosure, there's record keeping that is going to support the reasons why certain decisions were made, those things would help in the transition process while we are working through all of the other issues as well.
So Kamala, just to add to that point, is enhanced transparency. So a pre-qualification depository database, would promote transparency by providing access to information about registered foreign suppliers and contractors. And this will help, our government agency and the public to make informed decisions about the selection of the supplier and contractor. It would help with quality control. You will be able to establish, like, let's say, a minimum qualification criteria. It will help with local economic development, right? So those are some of the pros, but we're mindful of some of the cons as well.
So,
right?
Kamala, just to remind that Mr. Francois and myself needed to leave at 2:30. But just also to add to what Darlene had said, the last part of the point, which is regards to seeking exemptions, with regards to if need be, was basically the strategy that we sort of adopted. Therefore, asking the end users to interact with the suppliers, the foreign suppliers, try and encourage them as best as possible to get on board. And if not, they are refusing, and it is a critical activity that we need, that may compromise our operations if we don't get it. And we have explored all the different options to basically do that, right to the OPR, right to the minister, and request that permission based on these circumstances. Right? With that, we do have to depart. Mr. Francois, somewhat let me convey his goodbyes. Thanks again for having us. We will be in contact more so with the OPR. And we do have persons on who would continue to listen in and ask some more of the questions that we still have as well.
Thank you very much, Nasilee. Thank you. And thank you, Mr. Francois, as well. We do appreciate the time that you have spent with us. And I do look forward to us having you come back again, because a lot of this still does need to be worked out. And I appreciate that guidance which you offered just now as well to persons in terms of how to deal with an issue where currently you may not have a very clear way forward.
Yeah, well,
So, yes,
Right.
thank
You all very much.
everyone.
All the best. Thank you.
Yeah.
Thank you.
Yes. All right. Now, I did note that today would have been a really intense session, which is why we had extended it. Normally, our panel discussions do go on for 2 hours, but I had anticipated, yes, that there would be a lot of questions and a lot of need for discussion around today. Kurt, if it's okay and you can stay on with us, I'm happy with that.
Yeah.
Okay, I appreciate that you are also extremely busy too, but yes, thank you so much. Now there are so many questions in the chat. It's going to be a little difficult to get all of them. I'm going to just try to address a few, but I'm also going to invite 1 or 2 persons to unmute and ask their questions. Now, please, only if I ask you, right? We don't want to run amok here. But there's a question from Yvette Hoyt, which I thought, let me just ask, it might be an easy one to answer. She said, if you as an organization send your procurement staff for training, so CTS College, for instance, because they do the SIPS program, would this be a process that has to go through the OPR? And therefore, do these SIPS and certification providers, for example, need to be registered by the OPR?
So the training providers, so okay, is it a procurement process? If it is a procurement process, then yes, they are suppliers and contractors of a service. They should be registered on the OPR's procurement depository. And then you would engage them as such, whether it be as a consultant or for training, etc.
Okay, and a follow-up question there from Denicia was, does the OPR intend to do training that can certify staff?
So because the OPR is a regulatory body, it would be a conflict of interest for us to do training. That said, we have been working with training institutions in Trinidad and Tobago, and we've worked closely alongside the Accreditation Council. So whatever procurement related training programs that these institutions offer, the OPR together with the Accreditation Council, we would have come to an arrangement whereby we would look at the content and give guidance and feedback as it pertains to the content. And as well as and Lindy is now reminding me also, the Public Service Academy. So we are working very closely with the Public Service Academy, who has the responsibility for delivering training across the ministries, divisions, and departments of ministries. Yeah.
Okay. Now, Denicia, I know that you had several questions which you shared throughout today's session. So I want to ask you if you would like to raise 1 or 2 burning questions for you. If you want to unmute and just ask, not all of them, 1 or 2 that you consider to be really burning that you would want to be addressed by the OPR or by Kurt from the NGC. So Denicia Daly, did you want to ask any of your questions
Hi,
directly.
yes. Afternoon. I wanted to ask the question about ineligibility. I know one of the things that makes a contractor ineligible is unsatisfactory performance, right? But what I wanted to know was what was the aftermath of that? If the contractor, there's also the option the contractor could basically justify why whatever was done, right? But in the public body's view, the person is still ineligible because they would not have provided satisfactory performance. Would this public body now be penalized if they decide not to use this contractor, this specific contractor?
So you have to make the distinction with being placed on the OPR's ineligibility list, which has a specific process as versus the contractor providing poor performance. Well, the contractor providing poor services to your particular procuring entity, right? Because there's a vast distinction. So as it pertains to the OPR's ineligibility list, the regulation speaks to suppliers and contractors being placed on the OPR's ineligibility list where they consistently fail to provide satisfactory, consistently is the key word there, right? Fail to provide satisfactory performance, is found to be indulging in corrupt or fraudulent practices, is convicted of an offense under the act, right? However, because we are now interfering with persons' rights, and being placed on the OPR's ineligibility list has implications, for example, that you would be placed there, you would not be able to do business with a public body for 10 years, right? And also when you even look at the definition of supplier and contractor, specifically as relates to this particular ineligibility list, supplier and contractor is wide. It includes any person who is a director, a manager, a senior officer, a partner or similar officer. And when you look at the definition of senior officer, as it pertains to the ineligibility list, it goes on to a chief executive officer, a chief operation officer, deputy managing director, president, vice president, secretary, treasurer, chief financial officer, chief financial controller, deputy general manager, and the list goes on and on, right? So you will find the definition of that in section 58(1) of the Act of the 2015 Act. Mr. Lalchan would have said, the previous regulator would have said, when you look at it, it's everybody except the kitchen aid, right? With that in mind, when you look at the definition, the implications, like I said, is pretty wide, right? And the OPR has to do a balancing act. So suppliers and if a complaint is made against a supplier and contractor to be on the ineligibility list, it's a panel decision, and the supplier and contractor has to be afforded and accorded adequate opportunity to be heard and make representation, legal representation, before he's added to the ineligibility list. So there is that procedure outlined in the Act as well as in the regulations before being placed on the OPR's ineligibility list because of the implication. If a public body, after we've placed you on an ineligibility list, goes on to engage you, then there would be consequences to that, because you are not supposed to engage anyone who is on the ineligibility list, right? So that's that distinction. If it's a situation where a supplier or contractor is consistently providing poor services to you as an entity, then that is something that you could look at as a procuring officer, and you can make an internal decision with, of course, reasons and justifications as to why you may not want to engage the supplier and contractor further. So I see it as two different streams. I'm not too sure if that answers Denisia's question.
I believe it does, because I think what you're basically saying is in the evaluation process, I could justify in my records that this person has been consistently providing poor service. Yeah?
Yeah.
Okay, all right. So I understand that. Thank you very much for clearing that up. And in terms of, yeah,
Lindy had something else to say on that point.
I was just adding, we could be guided by the ineligibility proceedings regulations, and that sets out the procedure by which it is an accounting officer or or the equivalent in a public body could now report a matter to the office relative to the areas that Delrine would have identified under 58.3.
Oh,
Right?
okay.
So the ineligibility proceedings regulations go to that particular part, and you will see the guidance there in terms of how to relay a report to the office and the procedure to be adopted in treating with such.
Okay, thanks much.
Right.
You had
Thank-
another question? Oh.
I know because we have
In the
several, so I
handbook,
wanna
I
give-
saw you all keep referring to Supreme, but
Supreme.
Supreme, yes. Can you tell me a bit more about it, please?
So Supreme, okay, so because I'm not the technical person as it relates to Supreme, what I'll do is I'll answer that question. I saw the question that you raised. I will answer that question in writing because I'd want to get my ICT team to weigh in on that one in terms of how you would get access to it.
Yes, please. Thank you.
You're
Thank
welcome.
Yeah, so let's give someone else an opportunity. I was thinking Ria Rajkumar. She had a few questions in the chat as well. So Ria, if you want to unmute and just share with us what may be a remaining still a burning question following all the discussions that has happened. So Ria.
Hi, afternoon, everybody. Well, one of the major challenges that well, we're in the process of implementing the Act, and the whole idea of governance or the PDAC, the responsibilities for approval. Previous to the Act being proclaimed, we had a different structure for approvals and so forth. Now that the Act has been proclaimed, I think there's discussion, like for example, let's say we had a procurement manager and then a chief procurement officer. And they had different fiscal delegations of authority. A challenge would have been now, I think it was raised early on, someone, I can't remember who, in terms of the thresholds for the PDAC and the different levels. And also things like single sourcing under the regulations, they're saying that single sourcing needs to be approved by the accounting officer. Now, my organization is tend to be on the larger side. And if you have, let's say someone has justified single sourcing, let's say $5,000, why does that have to go? Well, does it have to go to the accounting officer for final approval? Those are some of the challenges we're facing in the practical implementation of the Act. And I just probably want to get some guidance or some clarifications maybe from the OPR as to how we will go about addressing some of those, because the Act is a little bit silent, some of the regulations a little bit silent on those kinds of operational matters, I should say, because it's delaying. Again, I think our friends from T&TEC were talking about the size of the organization, the number of transactions, and it's a similar thing on our side. So if you can probably, shed some light there, I'd be very grateful.
Right, no problem. I will start with the history of the legislation a little bit. So when the white paper was developed back in 2005, there was a push to move from a prescriptive approach to a more principle-based approach. And what does that mean? It's moving away from the fact that the governance, in terms of the regulators or the CTB telling you this is what you need to do, this is what you need to do, etc. And it's now giving you the flexibility to develop your own internal systems, right? So as it pertains to thresholds under the CTB regulations, certain thresholds were stated as it pertains to different industries, as well as approval levels, right? Now, what we expect public bodies to do is, because you know the nature of your business, you know the size of your organization, you are the best ones to be able to determine your thresholds. So I heard Miss Nasilee before indicate or speak to something where she said all the procurement between $1 and $6 million, something to that effect, would have to go through the PDAC. That is not the case. The entity is able to set their own internal thresholds as it pertains to what could go to PDAC and what should not go to PDAC. All the entity has to do is to document that in your special handbooks and guidelines and submit it to the office for approval. The office would have included in its documents online guidance and even sample forms as it relates to delegation of authority. So it's really incumbent on the procuring entity to make that determination internally. of course, depending on your process. So, a recommendation could be made by the CEO or, and that taken to the board, and the board approve your internal process. Once your internal process is approved and it works for you, like I said, it will assist it will assist you in the ease of business for your organization. That document just needs to be submitted to the OPR for approval. The legislation, the regulations, however, says that the OPR could set thresholds. The OPR has not set any thresholds at this point in time.
Okay, thanks. Just to clarify then, so we can go ahead, if our board has approved the internal governance structure, we can go ahead and implement that while we await the OPR to approve our special handbook?
So that your internal structure has to be, specifically in terms of delegation of authority, and that process needs to be documented in a special handbook and guidelines.
Okay, great.
Once
Thank
it
you.
is documented, it is then sent to us for approval.
Okay, great. Thanks much.
You're welcome. You mentioned, there's another area that she mentioned, single source. Yeah. Here you mentioned single source, but the same thing would apply.
Yeah,
So
mhm.
you got that right? Okay.
Yes, thank you.
You're welcome.
All right, good. Now, very early in the chat, we had a question from Salma Rahman. She asked, has the OPR compiled a comprehensive list of public bodies which fall within the ambit of the Act? And if so, is this list published as a guidance to suppliers and contractors?
So based on the definition of public body in the legislation, a public body is the Office of the President, the Parliament, the Judiciary, a ministry or department of a ministry, the Tobago House of Assembly, the municipal corporations, all the regional health authorities, statutory bodies with responsibility which is assigned to a minister of government, state controlled enterprises, service commissions. So in terms of a list that is public so far, the Gazette number 158 of 2020 outlines each of these entities, who is a ministry, who is a department of the ministry, right? Or a division of a ministry, who is a municipal corporation, that Gazette outlines and speaks to those. As it pertains to the definition of a public body under K and L, which is a body corporate or unincorporated entity in relation to any function it exercises on behalf of the state, as well as a body corporate or unincorporated entity in relation to any function, project, scheme, or arrangement, which is a little bit wider. We have published our request for named procurement officers, and it's incumbent on the public bodies to submit who their named procurement officers are and their accounting officers are. So that information is not available to suppliers and contractors. The Gazette, however, is a public document. Gazette 158 of 2020, and suppliers and contractors could feel free to download that document from the I think it's TT Law Courts. From the there's a website that speaks to legal notices on gazettes. Yeah, I don't know if that assists.
Okay, and I'm sure she'd be able to find it. Otherwise, you could find out the name and put it on the list.
I could put it in the FAQs, yeah.
Good. Thank you. Now, Trisha Chin had also asked a few questions. So Trisha, would you like to unmute and ask what may still be in your mind, your overall burning question that you'd like to get a response on? Trisha Chin.
Hi, good afternoon. Thank you, Kamla. Yes, I was wondering why the UN classification was used and not a commercial classification.
So that one would be a question for head ICT. I don't have that response at the moment. So that would be one I could loop in. Yeah, I could follow up on after.
Okay, excellent.
But the most I could tell you is that it would have been best practice. We would have looked at a number of systems regionally and internationally, and that one was selected. But in terms of the reasoning, I don't have that information with me.
Okay, there is, sorry, Trisha, I hope that was it. That was your major question, right? So you're good?
I did have another query, whether monies received from an international donor, whether those would be considered by the OPR to fall within the definition of public money.
It says by an international donor. Under Section 4, public money includes money spent or committed for future expenditure by a public body, or raised in accordance with written law for a public purpose? I would say yes at this point in time. Or money received or receivable by a public body. So if you're a public body and you're receiving money, then I would say yes. And if it's to perform a public function, or to perform some sort of project, or whether or not you have sort of scheme or arrangement which involves the use by it of that money.
All right. So there's a request in the chat for an elaboration to explain the single source, please.
So the regulation on procurement methods and procedures speaks to the process for single source. So suppliers, procuring entities are able to utilize the single source method of procurement, but they must comply with what the regulation says. In terms of the and have justifications as it pertains to why you're using the single source method. So for example, if you are a ministry, right, and you would like to use a particular state company, let's say you may want to use UDCOT, you would have to follow the legislation in terms of you'd have to justify your single source procurement based on what the regulations say. So for example, you'll have to check to see whether the price is reasonable, where you want to procure the provisions of goods, works, or services, which is usually provided by a public body. If it is in the case of an emergency, of course, the regulations tell you what is an emergency. The handbooks and guidelines would specify what is an emergency. So single source procurement could be used, but what is important with using it is you being able to justify why that procurement method was selected, because it's a non-competitive procurement method, right? I don't know if that helps.
Okay, so I think there may be a follow-up question to it in terms of why is it that over 5,000 should be approved by the CEO?
I think
So
that's
right,
the
so
same
that
question.
sounds like an internal, yeah, I'm not certain. That sounds like an internal administrative decision that has to be made. Yeah, the OPR would not be advising public bodies in terms of their thresholds for specific entity. So we cannot, for example, say to Heritage or say to NGC, well, you know, all contracts over 2 million, you need to get approved. That's because it depends on what is high risk, high value for you. What is, you know.
Okay, so I'm going to ask Delisa Bihari because she had a few questions as well. But while Delisa prepares herself, Melissa asked, which should be a very short, clear answer. An international vendor has requested signing of an NDA before providing financial information on the depository. Kindly advise how to treat with this. So,
Right. So, yeah, a non-disclosure agreement. So, an international supplier has requested of the procuring entity to. Is it that the international supplier is trying to protect its commercial information? Because if it's right, so if it's trying to protect its commercial information, I believe somewhere under section 26 or 27 of the legislation, it speaks to procuring entities being able to protect that information. Yeah, definitely. And in any event, the information on the financial information on the OPR's procurement depository is not outward facing. So that information all other suppliers and contractors would not have access to that information. Who would have access to that information would be a named procurement officer and your accounting officer of the particular procuring entity or any other entity that wishes to pre-qualify that international supplier and contractor.
Right,
Okay.
and I think that is that seems to be the issue, that they don't want that information publicly available to all. Can I ask that they send the information directly to us, and based on that, I can pre-qualify them, having received the information directly from them? Is that an option I could pursue?
That if you need to continue your business now, it's an option that you pursue. However, I would advise you that if it's incorrect information, the responsibility for the accuracy of the information rests with the supplier and contractor, and there are implications for submitting to a procuring entity incorrect information. So that might be a conflict on your part. So under section, I think it's 26, I just flip in. A supplier or contractor who submits information to the procurement depository shall be responsible for ensuring its accuracy. Also, where the information went under section 29, a procuring entity could disqualify a supplier or contractor where the information is inaccurate. So that would just be something that I would flag for your attention.
Mhm. All right, so
Okay, thank you.
You're welcome.
right, Delisa, did you want to unmute and ask any burning question?
Hi, good afternoon. Yes, I do have 3 questions. One, how do public bodies treat with donations? Are these organizations required to be registered with the OPR?
When you say how do public bodies treat with donations, which organizations? The organizations that are giving the donation or the organizations that are receiving the donations?
Right. So let's say, for example, we are giving a donation. We are the public body and we are giving a donation. Are those companies, are those organizations we are giving the donations to have to be registered with the OPR?
Well, it depends on how you go about giving them donations. So they are used, recently, it depends. So it depends on how you select the persons to receive donations. Is it a competitive process? Is it just a single source process? So that is a question really for your named procurement officer to determine. But I recently would have drafted a response on a similar question, and that one I could provide. I wouldn't want to, just answer off the cuff right now. So I could provide that question. I could provide a response to that question in detail.
Okay, great. Thank you. The second question that I have is just a query. Do public bodies have to keep the same name of calling the committee the PDAC, or is it that the public body, if we already have another committee with the same functions of this committee, can we keep that name, or do we have to rename it to PDAC?
So that's a question in terms of substance over form. I think once the substance of the committee is a PDAC and the regulation speaks to the composition of what is a PDAC and the function of the PDAC, you would be fine.
Okay, and
that is the regulation as it pertains to procurement methods and procedures, regulation 21. So as long as you are in alignment with regulation 21, the name is to me neither here nor there.
Okay, thank you. And the third question that I have, is there any timeline or deadline from the OPR as yet for the handbooks and guidelines to be submitted for approval?
Public bodies have been submitting their handbooks and guidelines for approval since prior to proclamation. So it is really as quickly as you can submit the document at this point in time.
Okay, thank you.
What I would say though is if as a public, so when we get challenges and complaints, what we do is we look at the timeline in terms of, we look at the timeline. So if it's a situation where it's a complaint prior to April 26th, while the law doesn't give us, the law gives us the ability to investigate retroactively, but we would be investigating not in alignment with the act, but in alignment to the procedures that would have been in existence at that point in time. You follow? So if your handbooks and guidelines have not yet been approved, we will be looking at your existing procedures. Yes. So if you're a state control enterprise, we anticipate or we expect that you would be following the SEMP manual. If you're a ministry, we expect that perhaps maybe your CTB policies or your central or your tenders rules, you would have that process documented.
Okay, great. That clarifies a lot. Thank you.
Okay, you're welcome.
Thank you, Delisa. Now there's a question in the chat from Dorelan Beckles-Lamont, and she asked, is the non-disclosure agreement information exempt information under the Freedom of Information Act?
Well, my off the top of my head, I don't know, because my main legislation is the public procurement legislation. So she would have to do some research as it pertains to that. I'm not sure offhand. I'll have to check.
Okay, I'm seeing a lot of persons saying thank you for an excellent session so far already in the chat. Just in case you guys are leaving, I'm going to ask our assistant to put the survey link onto the chat so persons could give us their feedback before they leave, please. Normally we just put it 15 minutes before, but we could do it now to ensure that persons can get the link to give their feedback. And I
I'm gonna-
want, yes, go ahead.
Sorry, may I ask a question to the OPR panel that I think maybe a point of clarification to most companies in terms of the, I know Lindy Ann, when you were doing your presentation, you mentioned that it was meant to eliminate the tenders committee. Now, I've not been able to find any definitive language in either the Act guidelines or the regulation that specifically dissolves the tenders committee. Because again, companies who are accustomed to having, for example, like my NGC, and the tenders committee is a function of the board or appointed by the board, like the HR committee or the OC committee, as the case may be, to review those items that would go before them for approval. So in terms of the, I guess, abolishing the tenders committee, can you point me specifically to anywhere in the Act legislation, in the Act regulation or guidelines that speaks to that? So that way, when I go back to make that presentation, that I can say, hey, listen, this is where they say we have to get rid of you, because I've not been able to find any of that. So it's inferred that
61.
it should.
So I will direct you to section 61. 2 of the legislation, which says, for the purpose of this act, a public body shall have a procurement officer who shall be responsible for what? Public procurement and disposal of public property for that body. So it goes on to further say where an officer who purports to act in such a capacity, so I'm looking at section 61.2 and section 61.3, right? So the point that I'm driving home there is the responsibility for public procurement and disposal is an operational function, and it rests with the named procurement officer. So the role of the board is more of a governance and a strategic role. We understand that board members would have had a role in the past in terms of approving procurement and disposal activities. However, that role is now the responsibility of the named procurement officer. That said, the legislation doesn't take away the power or the function of the board to question process, right? So they still have a role in the process, but they don't have a role in the approval or in the award of a contract.
So again, your tenders committee is appointed by the board. So if the board determines that they want the tenders committee to review any procurement for, as you quote unquote say, process that has been done or passed by the named procurement officer, what prevents the board from keeping the tenders committee?
Yeah, what I recall as well, some time ago, I don't know if it's in 2019 or 2020, when the letter was issued by the Ministry of Finance. And basically they were treating with that issue of the tenders committee or board, I think was board's involvement in terms of the process. And then another circular would have been issued regarding that they are to observe what it is the OPR has put out in terms of the regulations, the handbooks and guidelines, and what the Act provides. But that speak to the board involvement in terms of the award process. If it is, I am not mistaken. I'm not sure if that is useful information for you.
There's another guideline also. There's another circular that Minister of Finance issued in May that spoke to the tenders committee. So the tenders committee was referred to in the SEMP manual, and the tenders committee would have also been specifically referred to in certain legislation, right? So for example, regional health authorities, the responsibility for procurement was legislated that, their tenders committee would have a role in that. However, advice of the Chief Parliamentary Council has been that where there are two pieces of legislation, an old and a new, and there's inconsistency, the new one would take precedent. So there's legal advice to that effect, and the CPC would have also said that the old process would have been impliedly repealed, and it would now be up to the particular public entity to get it expressly repealed. That said, the OPR was or is relying on that advice that there's where it's where it's legislative that you have to have this tenders committee. This legislation supersedes that by implied repeal. The other, as it pertains to the SEMP manual, I was just looking on my phone to see if I could pull the circular. The circular was issued by Minister of Finance on the 10th of May, 2023, and he said with the proclamation of this legislation, all references to in the SEM to procurement of goods, works, and services, retention and disposal will now be superseded and replaced by this new legislative framework, inclusive of the guidelines and the handbooks issued by the Office of Procurement Regulation set out in the Act. Further, state-controlled enterprises are advised that in the event of any inconsistency, the legislative framework, the Regulations Act, handbooks, and guidelines issued, and the provisions of those of the latter will take precedence. So, to me, in couching your argument, that is what you will have to rely on. That here, what if you have a tenders committee with those specific functions, it will not be in alignment with the new legislative framework.
But again, so based on your individual companies, I guess internal governance structure, right? Because again, we don't just have procurement. Procurement is not the
Right.
be all and end all in the company. So
right.
based on our company's internal governance structure, which is then approved by the board, and they elect to continue with the tenders committee, how as a named procurement officer, right? So the board still has a non-objection rule, right?
Yeah.
So how
has to provide oversight. That doesn't.
No, and they have a non-object. I think they in the format of the
yeah,
I guess
they
in one of the
can either
guidelines.
object or not object, but they have to give reasons for their non-objection or objection.
So which, and this is just practical,
Yeah.
which accounting officer or NPO is going to go against an objection of their board? So the board still has an approval authority. So whether we call it objection or non-objection, there's no accounting officer or NPO that's going to go against an objection of the board.
Well, then what you have to do is put it in writing, because if there's a breach of the Act, 61.3 says a reference in this act to the commission of offense by a public body shall be construed as a reference to the commission of the offense by the procurement officer. So if the procurement officer could justify and say, well, here, what this was my recommendation, my board told this was my recommendation to do X, my board told me to do Y, I have done Y based on that, and there is written. The other part of the legislation would apply, which says, if a person, effectively a public officer who purports to act in such a capacity as the named procurement officer, that is the person who the OPR would deem to have committed the offense. Where the offense was committed with his direct consent or connivance, so there's the consent there. So the board would the board will now be putting themselves in the position of the named procurement officer. Right? Or where with reasonable knowledge, they didn't exercise reasonable diligence to prevent the commission of the offense. So the responsibility now for any breach of the act will no longer be with the named procurement officer, but it will be with the members of the board. That's how we have interpreted it, and that is the legal advice that we would have gotten. But from what I would suggest is you get, or your entity gets, some independent legal advice as it pertains to compliance with the legislation. Because there have been, and they could send it, Lindy is saying to me, they could also send it to us, because we've had experiences since, since 2015, where CEOs and procurement officers, accounting officers would have call the organization and say, here what? Call the OPR and say, here what? You know, we went through a proper process. We would have selected a particular supplier and contractor based on that process that we went through. And we would have gotten directives from the board, and we would have gotten ministerial directives, which would say, you know, do not award the contract to this person. The advice at that point in time would have been, let them put it in writing. Right? Today, the award went to the person who, you know, got it through the right process, and nothing is in writing. The board is still functioning, the entity is still functioning. So I say all that to say, sometimes as, you know, officers, we are placed in certain strategic positions to guard the public purse. And if we don't stand up and do the right thing, then where would that leave our country? You know, so sometimes it's a matter of having to stand up and you know, face your board. And
So it's not that there's been any dissonance between myself and the board. It's just that in terms of where the board is involved in our process, so based on our delegation of authority manual, right, that was currently developed, that we utilize in our company, the TC and the board has approval limits over and above certain values. So for example, if we're doing procurement for 50, 60 million based on some subsea pipeline where, you know, it would go up to 60 million, the board again would still have some approval authority in base of that level of spend. So, and they would want to have oversight of,
I was going to say the last thing I would tell you, and that is that you spoke to your internal process and procedure. So it sounds like you have documented internal processes and procedures. Has under section 30 of the legislation, procuring entities are supposed to submit their internal policies and procedures as it pertains to procurement activities to the OPR for us to approve. So that doesn't sound like a document. And the reason it comes to us to approve is because we have to ensure that it is in alignment with the act. So it may be that your document has not yet come to the OPR for approval. Because if we see the board putting itself in that position, then we would not approve such a document based on the handbooks and guidelines that we would have developed as it pertains to internal controls, because we do have a handbook and guideline on the website as it pertains to internal controls and how procurement units could be structured, etc. And we would have dealt extensively before with the role of the PDAC, the role of the board in governance versus, you know, so maybe you may need to, well, I'm not saying you as in you, but you know,
I think we all need to so that we end this discussion again, because the role of the board continues to be one of those areas that I think has gone a little bit vague and personal is not sure. I've heard some directors say they're hands off now, it has nothing to do with them, which
but it's not.
That's
it's
right.
not, because they have a fiduciary obligation and they have an obligation under the companies under the companies act. So it's effectively to make a distinction between what is governance and what is operational. If it's a situation where you cannot trust your management team or who you have hired to perform a public procurement function, well, then you need to hire, you know, right? But there's a role for governance.
I don't think so. It's not just a matter of trust. It is that there must be control systems. There must be processes that allows the board to feel confident in its oversight.
Right,
So,
but those processes are designed, but those processes ought to be developed by the board, right? So even when they develop a process, we still have to make the distinction between what is governance in terms of the board developing policy and strategy. So the board could very well say, this is the process, this is how to do procurement, this is the process, this is our policy, and leave and take themselves out of having to approve. You know, you could set up your internal thresholds, you could set up those administrative functions, but take yourself out from the approval and the award, because it would be a conflict.
Okay, so let's save that for another higher panel discussion.
Okay, I have one other question that I think needs I guess to the public forum. In terms of as you said, the definition of the name procurement officer as prescribed, I guess, in section 61.2. All right, we talk about the name procurement officer. Now, in creating or utilizing the depository, they would have created some user groups in terms of name procurement officer affiliate. I think that's what they call it, or delegate. Sorry, my apologies. So does that delegate only apply to the depository, or is that named procurement officer delegate now governed under the 61.2 with the same responsibilities as the name procurement officer?
That's what I'd have to come back to you on.
Yeah, because that one is very tricky, because if the accounting officer then appoints a named procurement officer delegate specifically for the depository, then that must be defined as such and pigeonholed that way. Otherwise, if I apply 61.2 to the name procurement officer delegate, then I have 5 name procurement officers in my organization.
Correct. So effectively the entity needs to decide who is the name procurement officer that is doing the procurement activity versus the name procurement versus the officer that has depository access. So authority versus access.
Yes.
Okay, I could look into that for you.
Appreciate it.
Okay, so I just want to remind everyone that we did put on the chat a few minutes ago the link to the survey. We're asking everyone to please give their feedback on today's session. In that also has the opportunity for you to provide recommendations for us on those areas that you'd like us to explore more. Okay, but definitely we are looking forward to doing a follow-up discussion on the role of the board under this new legislation now that it's been fully proclaimed.
Yes, I would love that.
Yes. It made Mr. Scotland's job easier.
Oh, yes. I'll invite my chairman too.
Yes. Okay, now there was also another easy question, which I'm hoping we could just clear from Joanne Connelly Mugabe. She asked, with regards to threshold and PDAC, what part of the act or legislation can this be found?
So right, so that would be a question that I think I answered before. It is, yeah, so you, in terms of thresholds, it will be found in the procurement, in the regulations as it pertains to procurement methods and procedures. However, procuring entities are able to set their own internal thresholds.
Yeah.
So we don't prescribe thresholds. You're able to set your own internal thresholds based on the nature of your business.
So just to give a sample, Joanne, as to what NGC did, we would have done our spend analysis in terms of for the last 3 years to look at what our critical or complex spend would be. And then we would have then done a TOR for the PDAC. We say, okay, well then over X amount of million and based on this level of complexity, this was what we would route through the PDAC. So this is what we did as a prime example of as to what goes to our PDAC in terms of spend. But I did remember, if I remember, there was, I think in one of the, I think it may be in the disposal guideline or regulation where I think they did mention like $100,000 threshold value. I think in 1 or 2 of the places they had $100,000. So I guess you may want to look into that. Sorry, tell me your name again.
Dalreen.
Dalreen.
Yeah, some
I
of
think
the
they didn't.
threshold values, you mean in the legislation?
Yeah,
Or the regulations?
the regulation, I think
So,
they had $100,000 somewhere in terms of disposal or anything over
Disposal.
that would attract.
I think that came in the note from the minister when he sent out the note. Sorry, this is Nasilee. I was kind of listening in, right? Sorry to kind of run in the last 2 seconds. Now, I hear you over the threshold, and just to kind of explain, it's sort of like an internal debate that we have internally. So from a procurement standpoint, we look at the threshold aspect. So I was kind of hoping to get more from a legal perspective in the act, because the argument that we are getting internally, mainly from our legal counterparts, is that the act, nowhere in the act in terms of PDAC speaks to thresholds. And that where they talk about PDAC, they just talk about it holistically. Where they spoke about thresholds, they spoke about the procurement, the procurement methods. So from their analysis, there wasn't anything that said, well, okay, you can also use your thresholds with the responsibilities of PDAC. So I was kind of looking for an alignment that says, well, okay, this is how you translate it based on the act and the regulations, that we can apply the thresholds.
So the legislation isn't that prescriptive. It just said, well, based on the what the minister would have issued, he said in organizing the entity under the new procurement regime, each state-controlled enterprises should note that section regulation 4.2 of the procurement methods and procedures, which states that a procuring entity may establish specific threshold values in special guidelines and handbooks, and determine such thresholds that take into consideration the scale of the operations at the various levels of the organizations, but at the same time minimizing operational risk. So it really is an internal administrative function. The OPR would not be saying to public bodies that this is how it should be done, or this is what your thresholds should be. So as it mentioned risk, of course, you need to decide what procurements may be deemed high risk and whether or not you'd want that to go to the PDAC. If it's a transaction of $5, you wouldn't want that to go to the PDAC, right? So it depends again on, you have to do your internal analysis just as Mr. Scotland would have said that NGC would have done theirs. But there's no legislative provision that speaks specifically to PDAC and thresholds. Remember, so the reason for the PDAC, right, was that there were complaints that, the accounting officer and the final approval of, because remember, procurement used to be centralized before, right? Now procurement is decentralized. So what that means is, well, it's each individual entity is doing their own procurement. The PDAC was put in as a buffer between the recommendation of the named procurement officer and the accounting officer. So the named procurement officer would make a after the named procurement officer goes through the procurement process. The named procurement officer will say, here what, I recommend this supplier and contractor for award, right? Had there not been a PDAC, the accounting officer would have just been signing off on that. So the PDAC was put in there as a buffer so that, process could be looked at, questions could be asked, for transparency purposes. So in terms of, what goes to the PDAC, that's an internal administrative, function or decision to be made based on, the needs of the organization.
So understood, and our procurement team totally agrees with what you're saying. But as I said, all I was saying or seeking clarification is from a legal perspective, right? Because that's where the disparity is coming, their interpretation versus ours. And at the end of the day, the tiebreaker would be the OPR to say, well, yes, this is the appropriate direction to take.
So what you can do is send a written request to the OPR, and we could provide a position for guidance that you may be able to rely on.
Great, much appreciated.
No problem.
Absolutely. Now, there is one very provocative question I want to ask. We are not going to be able to deal with it much. Maybe you'd be able to give a quick answer. It just came directly to me. The question is, can state bodies outsource procurement to other state entities that have capacity?
So right, that's a question that we've dealt with before. So some state entities, so effectively that particular state entity will also be a supplier and contractor. So there will be both a public body and a supplier and contractor. So therefore, as a supplier and contractor, you're providing a service, you have to be registered on the procurement depository, you have to be pre-qualified on the procurement depository. And Lindy is pointing me to which section? Right, you could also select consultants regulation in terms of procurement of consultants. You could also select consultants from among public bodies. Regulation 5 of that, Regulation 5 would stipulate that a procuring entity may utilize the single source method to award a procurement contract to a public body where the award of the procurement contract would be advantageous to the procuring entity and to the state. So the regulation specifically makes provision for that sort of transaction. So it's there, and it's also in the single source, section. Yeah.
Yeah, that's its own specific
Right.
regulation for consultants.
Regulation. Yeah. So under regulation, the regulations that deal with procurement methods, Part 5 speaks to single source selection, and under section 12E, 12E, it makes provision for that. It says where a procuring entity wishes to procure the provision of goods, works, or services, which is usually provided for by a public body. So if, let's say, I don't want to call a state control enterprise that usually provides services, but if it's usually provided for, that method could be used.
Okay. All right, guys, it's 3:30. And I know that we could go on for another hour, but I want to say thank you so very much, Delreen and Lindy Ann and your team at OPR. I really appreciate the fact that consistently you guys are here supporting and providing advice and guidance to the rest of us. Kurt, thank you so much. I've been trying for months to get NGC, and I'm so happy that the first time I called you, it was not a problem, and you agreed to come on and share your expertise and, some of your learnings with us. I know Nasilee is still with us, but I want to ask Annabelle Brasnell to please convey our appreciation to her team from T&TEC We appreciate they being able to come and share as well, because a lot of organizations do have a lot of questions. Some of them may be easy to resolve, some are not, but it certainly helps when we get together and we discuss it in this very calm and candid way to help all of us be able to comply. It is, as Delrine has said several times today, it's important for all of us to be able to work on this together to make it happen for the betterment of our country. That's what this is all about. So I'd like to thank everyone. Many thanks to all the participants. I know you guys have been here. This is 3 hours for what is a public discussion. So thank you all for staying with us, for adhering to our rules. We do have some persons who didn't name themselves fully. Oh, but I want to also say, Delrine, can you please ensure that you have gotten all of the questions?
I would have to, prior to the, yeah. I don't know if Christy could also copy and paste, but I would have copy and pasted some of the questions. I'm just not sure if I would have gotten all while because from the latter part. So I would have gotten all up to the end of the panel discussion. But while I was responding, I would not have gotten those.
All right, Crystal, can I ask you?
You can just copy and paste all.
Yeah, just download
in a
the
Word document. Yeah, if she could. Let me see if I could do it.
Because I'm looking for Anya. I'm not, is Anya here? Oh yes, Anya, is it possible for you to download the chat?
Certainly, not a problem.
So that way I am sure we'll be able to get all the questions and send it to you, Delrine.
Great, perfect. Thank you so much. Thank you for having us.
Absolutely, it was our pleasure. And I do want to identify 2 persons who have been with us all the while though, because we need it for our records. We have KI, who I am sure is not the chutney singer. So could we please find out who KI is? I've been trying in the chat and we didn't get a response. And also there's a J Sampath. Can we just find out who you are, please? And this is especially if these same persons write us afterwards asking for CPD hours. We can't.
Hi. Hi,
Yes.
this is Jerome Zampat. I'm from the Manager of Procurement and Logistics with the PTSC.
Okay, hi Jerome. So are you on 2 devices?
Yes, I am. I'm
Okay,
listening on my headphones.
Okay, good.
Okay.
All right. So thank you for clarifying that. KI is.
Are you hearing me?
Yes, we're hearing briefly.
Well, I'm driving. I've been driving, so that and it came up with the initials. But this is Keith London.
Keith London. Okay, so let me just take a note of that.
So it's KL, not KI.
Okay. Well, Keith, thank you so much for joining us as well. I did try a few times, but I guess that explains it, the fact that you were not able to respond to the chat.
So I had to pull aside as you asked.
All right. Okay. Well, thank you all very much. It's been really, really a great session. A lot of sharing. We have learned a lot, and I look forward to us hosting everyone again as we continue our discussion so that we can all improve the way we do things here with our governance practices. Thank you all and have a wonderful evening.
Thank you. Bye.
Thank you. Bye. Thank you. Bye.
Bye.